Hi, everyone. Welcome today on this rainy spring day. My name is Beth Cohen-King, and I'm the Marketing Director at Margolis&Bloom. So we work with our clients to find the best estate planning or elder law solution for each client's unique situation and goals. And we bring to this effort more than 30 years of experience and a commitment to providing the highest level of personalized service. Oh, there we are. So today, Harry's going to be presenting on recent elder law cases from 2020 to 2021, diving into several of the high-level points and talking about the significance for your own future planning. So we have many of these cases also written up on our website in the blog section. So if you want follow-up afterwards or to read a little bit more on the details of it, please go to our blog section. And for those of you who've asked, I can send out a recording, or both a recording of the presentation, but also the slides, if that helps for your reference to after the presentation. So just a little housekeeping before we get started. If you have questions, which I'm sure there will be questions that come up, please type them into the question panel, which is in your control panel on the right side of your computer, and we will dive into those at the end. So without further ado, I'm going to turn it over to our presenter, Harry Margolis.
Okay, thank you, Beth. So, and welcome everybody. And there have been a lot of cases lately, and we're going to go through them and talk about them. The courts may have been taking some time off during COVID, but I think they're catching up now. And you'll see a number of these cases have to do with mass health, and I would say, for the most part, I'm not sure what the number of those cases were, but it's something like Mass Health 0, beneficiaries 3. So, but they're not all Mass Health cases. So there's also some guardianship and other cases. So let's dive in. So the first one we'll talk about, and I'm doing these in reverse chronological order. So there's actually a new one I'll talk to you about at the end that I was just writing up and don't have slides on. Which was decided on March 31st. But March 24th, this is a guardianship case, the guardianship of AR, Massachusetts Appellate Court. And it has to do with a Rogers hearing in addition to the guardianship itself. And so the first finding, which is interesting, is that a medical certificate is not admissible as evidence. But then the court said, unless there's no objection, it is admissible. So, as you probably know, in order to file a guardianship or conservatorship matter, you need to file also a medical certificate stating the need for the guardianship or conservatorship, and that's that's necessary to file the case. But it's not sufficient evidence unless there's no objection. If there's an objection, the medical certificate is not admissible. But in this case, they had a psychiatrist who appeared and testified, and just a piece of personal knowledge, privilege. It turns out someone I used to know decades ago, but haven't seen her in decades. She testified, and she testified. The court found, the appeals court found that her testimony was sufficient for the issue of whether a guardianship was necessary, but it did not satisfy the substituted judgment standard under the Rogers case for the administration of antipsychotic medications. And so the court states here what the substitute judgment standard is in Rogers cases. And it is in a substituted judgment determination, a judge must ascertain what a person would choose if he were competent. The determination is subjective rather than objective and requires consideration of a person's values and preferences, and several factors guide this determination. 1, that person's expressed preferences. 2, his religious convictions. 3, the impact on his family. 4, the probability of adverse side effects from treatment. 5, his prognosis with treatment. And 6, his prognosis without treatment. And in this case, the court found that these factors were not all satisfied. Here, the admissible evidence tended to establish that AR had the present capacity to weigh the risks and benefits of certain medications and to make informed treatment decisions related thereto. This is underscored by his choice to refuse one medication, Vega Sustena, because of its side effects, while simultaneously voluntarily taking another medication, Prolixin. So he wasn't just saying, I'm not going to take any medication. He was using his own judgment in what he would accept. In sum, Dr. Goodman's testimony alone was insufficient to meet the department's burden. So they said okay to the guardianship, not to the antipsychotic medications, but they did open the door saying, well, if circumstances change, come back and go back to the probate court and show it that circumstances have changed, and now we can meet the substituted judgment standard for Rogers. So that was the guardianship case. Now getting to our first mass health case, Guilfoyle versus Secretary of the Executive Office of Health and Human Services. And I want to say that this is a case that was litigated by Lisa Neely of Merrick O'Connell, and she is really the leading litigator on these cases in Massachusetts. This was decided on February 9th. So here's the facts of the case. Back in 1999, Dorothy Frank transferred her home to a family realty trust. And as you'll see, this is a nominee realty trust. On the schedule of beneficiaries, executed a year and a half later, she gave herself a life interest in the trust, with the remainder passing to her 5 children as joint tenants. Another 6 years after that, in 2017, she moved to a nursing home and applied for mass health coverage, and Mass Health rejected her application, finding that her interest in her home, so that was her interest, remember on the schedule of beneficiaries and on the nominee realty trust, was valued at $109,000, rendering her ineligible for benefits. So not only was Mass Health saying that this is a countable asset, her life interest under the trust, but in addition that it's countable. So a home, as you probably know, homes are normally not countable assets, but if they're in a revocable trust, the Mass Health takes the position that they become countable, and that looks like they took the same position here. It's unclear from the decision how they came up with the $109,000 valuation. Ms. Frank appealed. Ultimately, this went all the way to the SJC. During the litigation, she passed away, and her daughter, who was the executor of her estate, her name got attached to this litigation. So that's why it's not Frank versus Mass Health. So the SJC determines that the trust is in fact a nominee trust, and as you probably know, a nominee trust is a funny sort of hybrid. It's called a trust, but it's really more of an agency agreement. As a trust, as the court says, it establishes only a principal and agency relationship between the beneficiaries and the trustees. Further, the court says it is a feature that the trustees have no power to act in respect to the trust property, but may only act at the direction of the beneficiaries. That is key to the nature of a nominee trust. Again, the trustees are agents on behalf of the beneficiaries, and so they can't sell the property, and they may be able to rent it out, but depending on the terms of the trust. But there are a lot of things they can't do without the direction of the beneficiaries. Upon the transfer, the court says, of Ms. Frank's property to the trust, an immediate property interest vested in the beneficiaries. Ms. Frank retained no rights of ownership. So in effect, the scheduled beneficiaries is just like a life estate deed. She retained a life interest and on the scheduled beneficiaries, and the other beneficiaries, the remainder interest holders, had a vested interest. So she could not order them to order the trustees to sell the property. Mass Health was arguing that the trust was somehow revocable by her, but as only one beneficiary, there's no way she could order the trustees to reconvey the property to her. So here's what the court says: because a life estate does not permit an individual to sell the home and distribute the proceeds, we conclude that the retention by an applicant of a life estate in his or her primary residence does, and here was a typo, they meant to have not in there, but they said does render the property a countable asset. I know it's not, because everything else in the court decision went that way. Accordingly, it was error to include the value of the property as an asset in the plaintiff's Medicaid eligibility determination. So basically, even though it's a nominee trust, they're saying, given the scheduled beneficiaries, it's just like a life estate deed. And so that was that case. The next case is not a mass health case. It's a case as to capacity and undue influence. It's dated January 12th of this year, and it's Joseph A. Haddad versus Marcel A. Haddad, a Massachusetts appellate court case. And these are a couple brothers duking it out, and involve the estate of their father, Antoine. And in 2011, he changed his estate plan in favor of his son, Marcel. And at that time, he was showing some signs of aging. He had fallen at home. He had actually had some surgery in the past. He had allowed a pot of water to boil away when he fell asleep. So Antoine, Marcel, and Antoine's brother-in-law, Marcel's uncle, John Shamey, met with Shamey's lawyer to prepare a new estate plan for Antoine, who did not speak much English. So Marcel and Shamey translated between English and Arabic, and the lawyer prepared a new plan. At the time, Marcel was single. He lived with his father and was his primary caretaker. That his brothers, Joseph and Alain, had both moved out of the house when they had gotten married. After the fact, after 2011, Antoine's cognitive ability continued to decline, and by 2013, his doctor noted that he was, quote, alert but less oriented, somewhat confused. So he died in 2017, and Joseph and Alain challenged the 2011 changes to the will, arguing both that Antoine lacked capacity and that Marcel exercised undue influence to get him to change his estate plan in his favor. At trial, the court found that there was no undue influence, but that Antoine lacked testamentary capacity. So it disallowed the 2011 changes based on the issue of testamentary capacity. And often those are related issues, because one of the factors for determining undue influence is lack of capacity. That makes you more susceptible to undue influence. But in this case, the court, I think probably because the uncle was there to testify as well, that there was no undue influence. But on appeal, the Massachusetts Appeals Court reverses, and one of the issues you'll see in the next slide is that it seemed like the judge put a lot of weight into the fact that Antoine didn't speak much English, and that it found, the appeals court finds it was in error. So anyway, it reverses. So there, first of all, it says that there's a presumption when a will is presented that the testator had capacity, but that presumption can be switched relatively quickly. All you need is some evidence of testamentary, some evidence of lack of testamentary capacity to shift the burden of proof to the proponent of the will. However, it finds that there was actually no evidence of incapacity presented in this case. So this is what they say. There was no direct evidence to rebut the presumption with respect to the date, July 12, 2011, the day that Antoine executed his new estate documents. No percipient witness testified. I'm not exactly sure what percipient means, but maybe someone can explain that. But no percipient witness testified that Antoine lacked testamentary capacity on that date, nor was there any expert testimony that Antoine lacked testamentary capacity on the critical date. the neurologist who did testify did not tie his testimony concerning Antoine's Alzheimer's disease to Antoine's capacity on any date, let alone on the critical one, to understand the purpose of the will, the nature of his property, and the persons who would claim it, stating the standard of testamentary capacity. It then considers whether, given there was no direct evidence as to his incapacity, was there circumstantial evidence? And it says, similarly, looking at the year leading up to the July 12, 2011, although Antoine was prone to falling, had short-term memory loss, was becoming lethargic, no longer drove, and had diminishing facility in English, he continued to live at home fairly independently. He remained conversant in his native language of Arabic, which he continued to understand. And as I said, the court faults the trial judge for focusing so much on Antoine's weakness in English. Although a lack of facility in a particular language may well bear on a testator's understanding of the provisions of estate documents in that language, and thus the validity of their execution, it does not prevent a testator from having the capacity to execute such documents, which is the issue in this appeal. So basically, I think that what you can take from this is that the court is going to need real evidence to overturn a will. So there's you start with the idea that the will is valid, and if you're going to show undue influence or lack of capacity, you have to have good evidence, and it has to be specific as to the date in question. Not that someone's, I suppose, again, looking at the circumstantial evidence, if you can show that somebody really is out of it all the time, that's probably pretty strong. But in this case, it looks like Antoine was getting older, recognized that Marcel was the person taking care of him, the one who hadn't moved out and started a life in a new house with a family, and wanted to take care of him, and was allowed to do that. I think if you have a case like this, the more evidence you have of the client's wishes and why, an explanation of why they're doing what they're doing, I think is a good thing, and take notes on that. And meeting with the client alone is important, and it's not clear whether, clearly the lawyer could not meet with this client alone because of the language barrier, but could have met without Marcel in the room, and that would be something that could help. On the next slide. There we go. So the next case in the matter of the estate of Jacqueline Kendall, December 28th, 2020, is an interesting case having to do with estate recovery and Mass Health's right to bring a claim in a late filed probate in the basically three-year statute of limitations on Mass Health's claim. So Jacqueline Kendall died in August of 2014. She owned a half interest in a house in Gloucester. In 2018, and the house actually went to I think half to her children and to her brother. And I guess in 2018 they decided it was time to sell the house, and they filed for late and limited administration pursuant to Mass General Law 190B Section 31084, and that's important because this is not a full probate. This is just a form of probate that is permitted to ascertain title to property, to real estate. So they filed the probate. Mass Health filed this claim for $104,000 and some odd dollars, and the administrator rejected that. There's actually in this week's Lawyers Weekly, in the REBA News, the Real Estate Bar Association news part of it, there's actually an article written by Meredith Fine, who's a lawyer who brought the case, who represented the family, and she said that the reason she realized that she could challenge Mass Health's claim was because of a REBA meeting she was sitting on, a breakout session on conveyancing real estate out of probate, and one of the speakers mentioned the 3-year statute of limitation, and she remembered that when this case came up. So anyways, they challenged it, and as you know, most creditors must file claims in probate or in district court within 1 year of the date of death of a decedent against whose estate they're filing their claim. But MassHealth has additional rights. It's a preferred creditor, so it can file a claim within 4 months of the probate being commenced. It can file a claim within 1 year. It can file a claim within 4 years after the probate is commenced, or after a year has passed, it can start. It can get a public administrator to probate the estate on its behalf. So it has a lot of outs, or a lot of ways to assert its claim of estate recovery. And as you know, when you file probate, you got to let MassHealth know so that it can file its claim. So it has a lot of ways to file. The question is, does it have even more? So can it file does it have more than the 3 years? And the court says no. So it says that pursuant to Mass General Law, Chapter 190B, Section 3108, there's an express bar, a 3-year ultimate time limit. This 3-year ultimate time limit functions essentially as a statute of repose, allowing only very limited activity after the 3 years. On more than one occasion, we have characterized statutes of repose as having the effect of placing an absolute time limit on liability. Further, the 3-year ultimate time limit is a critical provision ensuring the orderly settlement and liquidation of estates in a relatively expeditious manner. We conclude that if the legislature intended to create an exception for MassHealth to this ultimate time limit, it would have done so expressly in that particular provision. We will not read in such an important exception inferentially. We're not reading, not sure if I put the stresses right on that sentence, where the legislature advantaged MassHealth over other creditors, it did so carefully and expressly. So basically it's saying MassHealth does have all these other rights to pursue its claim, but not beyond this 3-year time limit. And if the legislature wanted to give it more time, it certainly knew how to do it, because it did it in these other cases. And MassHealth argued that, well, everybody's going to delay probating their estates because they want to wait out the 3 years so they can escape estate recovery. And yeah, that might be true, but MassHealth can always should have good records of cases where there's a house involved that's going to go through probate, and if they need to, they can always engage a public administrator. But this could be important for you all to know about in cases that you may run across. So here we're going from MassHealth to undue influence and elder exploitation. This is a case of Steer v. Steer, Superior Court case in Dukes County. It all happened on Martha's Vineyard and was decided at the end of last year on December 16th. So Gloria Steer lived in her house in Oak Bluff since 1982, and she had actually been a bookkeeper, I forget what business, but had a pretty responsible job. But she retired and then became a victim of scammers, eventually losing her life savings of approximately $800,000. She subsequently took out a reverse mortgage and continued to send money to scammers. And so since she was short on funds, she decided to put her house on the market. So when this happened, she was at a family function, and her nephew, Lyle Steer, and his wife, Aurelie Cordier Steer, suggested that they might help out. And that their concept was that they would buy the house from her, pay off her debts, and they would basically use it as a weekend house, but she'd be able to continue to live there. And there were some emails that went back and forth. So, so Lyle offered Gloria $500,000 for the house. This is a quote from the email, with all the conditions that we discussed. That is, you would live there, but we would own the house and pay for all the taxes, insurance on the property, and any big ticket items that hopefully will not happen: roof replacement, plumbing, HVAC, and you would be responsible for all the monthly expenses. Cable, phone, electric, heating, and oil. He also offered to handle all legal expenses related to the transaction and to cover back taxes at the closing. And at the end of the email, he added, "We will also need to put in some conditions related to health matters while you're living there that we can discuss as part of the process." So clearly they were already concerned that they didn't want to be taking care of her if she started failing. He also wanted to keep it all private. So he said in another email, "We prefer you keep this between us. We are a little concerned with family dynamics, but if you feel that you want to discuss with the family, I would completely understand. That is your call. But from our standpoint, we are keeping this private." So they got an appraisal of the property of $1.4 million. The transaction went through. Lyle and Orly started visiting on weekends and also started taking over, basically trying to make the house the way they would want it. And so they started getting rid of Gloria's stuff. She got upset. They suggested maybe she'd be happier in elderly housing. And then in 2018, they brought an action to evict her. She by then had talked to other relatives who were pretty upset with Lyle and Orly, and they helped her get a lawyer to challenge the eviction, arguing undue influence and fraud. So in court things don't go very well for Lyle and Orly. The court finds that Gloria made an unnatural disposition of her property, that she was susceptible to undue influence, and in that regard, they cite the fact that she gave all of her money to scammers, that Lyle and Orly had an opportunity to exercise undue influence, and that they used that opportunity to procure property by improper means, basically going through all the elements of undue influence. Further, the background of Gloria giving her life savings, I just said, and then her reverse mortgage proceeds away to scammers, shows that she was susceptible to undue influence. They also found fraud, basically because Lyle and Orly had told Gloria that she could continue to live in the property for the rest of her life, when that was probably never their intention. In addition, they were trying to push her out, and they found that involved intentional infliction of emotional distress. For an example, in an email to his siblings, Lyle made clear that they were acting intentionally, quote unquote, refreshing the house, specifically to make Gloria feel less comfortable at the property. Lyle said that he and Orly needed to make Gloria realize that 56 Bayview was no longer her house. So the court orders that the house goes back to Gloria, plus that they pay her $100,000 for the intentional infliction of emotional distress, but that they get, but other than the $100,000, that they would get their money back. So moving right along, another Martha's Vineyard case. So this is a case that looked like it was going to involve some really interesting things, including tribal law. So Pamela Glavin and Carl Manning Wittes lived together in a house owned by Wittes in Akina on Martha's Vineyard for 35 years, but they never got married. So in 2014, 2 months before his death and while undergoing cancer treatment in Arizona, Wittes wrote a will by hand, giving Glavin a life estate in the Akina house. How do you pronounce that? Aquina, I think. The will was not witnessed. So we have here a holographic will. So then he died, and Glavin filed for intestate probate of his estate, but she didn't mention the will because she had been advised that it was invalid. And she listed Wittes' brother and sister as the only heirs. So the problem was, so she did that, and then the brother and sister decided that they wanted her out of the house, and they wanted the house, and so she challenged that eviction. And she argued, first of all, that the will, which was signed in Arizona, was valid under Arizona law. Second, that she and Wittes were married as per tribal, Wampanoag tribal law, so she had rights as a spouse. And third, that she and Glavin's brother and sister had an agreement that would permit her to stay in the property. And the probate court dismisses her petition, and then it goes on to the appeals court. And the appeals court says on the first two matters, it can't, basically she screwed up on the probate and she can't reopen it. I mean, she probated it, she alleged that there was no will. She didn't say that she was married. It's too late now. You could have argued that in the first place. But it still remands the case because it says, well, the issue of whether you had an agreement with the Glavin's brother and sister, that's an issue of fact, and we don't know whether you had an agreement or not, and whether it's enforceable. So that should not have been dismissed. There should be a trial on that issue. So here's another case. It also involves Arizona, and it's terrible facts. So in 2000, Donald Bellinger and his wife moved from Massachusetts to Arizona. In 2007, they got into a fight with their neighbors on water rights, the Armand and Simone DePrins, and they lose. They then leave Arizona and move to California, where Mrs. Bellinger commits suicide. A year later, Bellinger moves back to Arizona with his daughter, and he creates an irrevocable trust for their benefit, and the trust is created in Massachusetts, so that's why we still have a Massachusetts case. And it's a question of creditor access to this trust. So he creates this trust, he transfers assets into it, and then the next year he shoots his neighbors, and a day later he kills himself. So then the DePrins, his neighbor's son, sues his estate for wrongful death and wins, and then he seeks to enforce his judgment against the trust. And the First Circuit certifies a question to the Massachusetts, to the SJC, saying, well, can we get to this trust, or is it protected? So the certified question is, on the undisputed facts of this record, does a self-settled spendthrift irrevocable trust that's governed by Massachusetts law and allowed unlimited distributions to the settler during his lifetime protect assets in the irrevocable trust from a reach and apply action by the settler's creditors after the settler's death? So basically, can we get to this trust? Because he was a beneficiary during his life, but it's irrevocable, and then he died, and his daughter is the beneficiary. And the court says that since the cause of action arose before Bellinger's death, remember, he shot the DePrinces one day and killed himself the next day, so it was the wrongful death action accrued the day before he died during his life, then the trust is self-settled and it is reachable. The court says it would be incongruent for a self-settled trust not to protect the settler's assets from creditors while the settler is alive, but to have it protect the settler's beneficiaries from the settler's creditors after the settler's death, when, absent the self-settled trust, they would not be so protected. We therefore hold that a settler's trust does not become protected from creditors on the settler's death. So as you know, in Massachusetts, you cannot create a self-settled asset protection trust, though you can for third parties. So he could have created a trust for his daughter, and who knows whether if he had not named himself as a beneficiary of the trust, whether the decision of the SJC would have been different. But since he named himself a beneficiary, and he was alive, of course, when he committed the wrongful act from which arose the claim, then the funds are unprotected. The court goes further to prevent the son of two murder victims, I guess looking at the equities here, from financially recovering for their wrongful deaths while protecting the murderer's assets from his beneficiary would contradict the well-established public policy of this Commonwealth and condone the actions of a settler who, it can be inferred, thought he could use the protection of a trust to shield his assets from the consequences of his violence. The equities here simply do not allow Bellinger to murder the plaintiff's parents and then leave the plaintiff with no recovery in the subsequent wrongful death action, despite Bellinger's possessing substantial assets during his lifetime. So it's not totally clear from the dates how much of this was totally planned, but clearly it could have all been planned. So we're getting, I see this is taking time. I want to leave some time for questions. So I'm going to actually switch off the PowerPoint here. Again, as Beth mentioned, all these cases are in our blog at the margolis.com website. But I am going to switch to a case where I have not put on the slides yet because I'm just writing it up just to talk about it. This is the case that was decided on March 31st, called in the matter of the Valerie R. Petchey Supplemental Needs Trust. And this involves a case that a number of practitioners used to make, I hope nobody's making it anymore, where they created third-party supplemental needs trust, but used D4a Trust forms. So as we just discussed with creditors, you can create a third-party asset protection trust that's protected from the beneficiary's creditors, and you can also create a third-party supplemental needs trust where the trust provides that's for the benefit of somebody with a disability during their life, and after they pass away, can pass to other beneficiaries, and that's fine for all public benefits programs. But you cannot, it's just like you can't create a self-settled special needs trust. For the most part, you can't. You can't create a self-settled asset protection trust. You can also, in most cases, cannot provide a self-settled special needs trust. So if you create a trust for your own benefit and then apply for Mass Health or apply for SSI, if the trustee can make payments on your behalf, that's going to be counted as your asset. However, there's an exception, and that's a D4a trust, and under 42 USC 1396P D4a, if you create a trust with your own assets for your own benefit, if you're the sole beneficiary, and if you provide that at your death, remaining funds will reimburse Medicaid, Mass Health in Massachusetts for your expenses paid on your behalf, then that's a safe harbor, and you can shelter your own assets. But what some practitioners unfortunately did is they used that same form for a third-party trust. So they included in the trust this payback provision, which was totally unnecessary, because you need the payback provision if it's a self-settled trust, but not if it's a third-party trust. And this is what happened in this case. And Albert Petchey created this trust for his daughter in 2001. He then died in 2007. She later died in 2015. And the trust, just to give you a few more details, he transferred $200,000 into the trust in 2001, and then his estate plan said that that the rest of his assets went in the trust when he died in 2007. And so after Valerie died in 2015, the trustee said, hey, this was a mistake. We shouldn't have this payback provision in this trust because it's a third-party trust, and he sought to reform the trust. And Mass Health opposed the reformation. They also tried to get the trustee kicked off as trustee, because said he shouldn't be doing this. He should just be paying us what he owes us. And the probate court, the reformation effort failed, because the court's Mass Health argued, well, it's true that in terms of Valerie, the daughter, there's no need for this payback provision, but Albert, the dad, might have wanted to qualify for Mass Health himself. So that's why he that may be why he put a payback provision in this trust. And the trustee argued, well, he kept a lot of money. He wasn't about to apply for Mass Health. And just to clarify, you need the payback provision in the trust, or you need it to be a D4a trust in order to qualify for an exception to the usual transfer penalty for transferring assets. So if I transfer assets, I'm going to be ineligible for 5 years after I transfer assets. But if I transfer assets into a trust for the sole benefit of a disabled individual under the age of 65, then there's no transfer penalty. So I can do that. I can take my $1 million and go to a nursing home, take my $1 million today, put into a sole benefit trust for the benefit of somebody who's disabled tomorrow, and or today, and then tomorrow qualify for Mass Health. So the Mass Health says, well, even though he kept a lot of assets, he could have been he wanted to have the out of qualifying during the next 5 years. So that's why he used a D4a trust. So the probate court agreed with Mass Health, and the trustee then appealed. And the appeals court split in 2 ways. First, it said, yeah, well, maybe that makes sense with that first $200,000 he put into the trust when he first created it, what Mass Health says, because he doesn't want to create this 5-year transfer penalty. But it made no sense for him to use a trust with a payback provision when he died, because then it's too late to apply for Mass Health. So the penalty doesn't matter. So they reversed in part and agreed in part. So they said the payback provision still applies for the first $200,000, and for the other whatever went into the trust through his estate, through his will, that's protected. We're going to reform the trust with respect to that. So basically, Mass Health has a claim, according to the decision, just against the first $200,000. We don't know how big their claim was. That wasn't divulged in the decision. But this was a 2-1 decision. So there was a dissent that by Judge Peter Rubin, who says basically, I guess a couple things, but that Albert didn't need to use a D4a trust. So a D4a, as I explained it, a sole benefit trust qualifies to avoid the transfer penalty for transfer of assets. A D4a trust is a form, or is accepted by Mass Health as a sole benefit trust, but it's also considered to be a sole benefit trust if rather than saying payback Mass Health, the trust just says when the beneficiary dies, whatever's left in the trust will be payable to her estate. And that's significant because estate recovery by Mass Health is only for benefits paid after age 65 or for nursing home benefits. Now, it's possible that in this case that Valerie was never in a nursing home, and perhaps she died before age 65. So if it were just a claim against her estate, Mass Health would receive nothing. But if it's a provision of the trust that it be reimbursed, it might receive a lot more. So it's a split decision, but it came out kind of as a split, with part of the funds being protected and part not being protected. So we're now at exactly where I was going to end the talk. But maybe Beth, I don't know if we got any questions, but I didn't leave much time for them. But we could extend for another few minutes if there are questions, if people who want to stay on may, and people who want to get off and continue the day also may do that. And anyone who wants to write to me with any questions or comments can do so at hsm@margolis.com.
Great. So thank you, Harry. I actually don't see any questions, which is surprising, unless people want to furiously type them right now. Thank you so much for presenting all this. It's a lot of information, and some of the stories are frustrating and heartbreaking, and certainly show that we need to make sure that we're planning and advocating for what's right and just all the time. So what Harry said in terms of, you can write to him, his email. You can also go to Ask Harry and put in a question there at his website. So that's another option for you.
Yes, askharry.info is a website I have that where I just answer questions online.
Yeah, so wait, a few are coming in right now.
Okay. I also want to add, the case I was just talking about was litigated by James Knutson at Knutson and Burbridge in Wakefield. So I think he deserves credit for that. Okay.
So 2 questions. Wondering about protections for unmarried couples. What that says. And where home ownership in one person's name. So I think those two go together.
Well, so I guess there's different kinds of protection. I'm not sure if there's homestead protection, but there's also protection if one of them. I guess it depends what you're protecting against. So there's creditors, and that would be homestead protection or a trust. There's mass health protection, and that's harder because if the person who owns the house gets mass health, then there's going to be a claim. There's no exception for a non-spouse. So it may be a reason to put the house into a life estate or an irrevocable trust to avoid a mass health claim. But it's also, if you're going to protect it after the owner dies for the survivor, then a trust could also help out, whether it's revocable or irrevocable, because that would be a third-party trust for the survivor and could be totally protected relatively easily. I'm not sure if that answers the question, but.
Well, she can follow up with you.
Right.
More to it. And then, is it ever wise to use a life estate in connection with trying to qualify an individual for Medicaid?
Yes. I mean, the life estate is going to cause a penalty period when you create it, but it's a very good device. There are pros and cons between life estates and irrevocable trusts. I mean, the nice thing about a life estate is that it's really easy and simple to put in place. I encourage people to, if they do a life estate, and for the grantor to retain a testamentary power of appointment, because circumstances change. I just got an email the other day from someone who gave a life estate remainder interest to her son and daughter, and then her son died, and she didn't want and she wanted the house to go entirely to her daughter, but it was complicated because it really goes to the son's estate, and if she had retained a testamentary power of appointment, she could always change the ultimate disposition of the life estate. The problem with life estates is, I mean, there are pros and cons here too, but if you sell a life estate while you're alive, part of the proceeds go back to the original owner based on the person with the life estate, based on his or her life expectancy at the time, and those would be unprotected. In addition, the owner could only use their $250,000 exclusion, capital gains exclusion, for that portion. So the portion of the proceeds going to the son and daughter, in the example I just gave, would not you wouldn't be able to use that exclusion and would be subject to tax on capital gains. And a lot of those things could be avoided and protected against with a trust.
Okay, so I think that is it for now. But if you do continue questions, you know where to find us. And we are going to have a recording of this. And if you are interested, you can email me, bck@margolis.com, if you want a copy of the slides, if that helps. So with that, I think enjoy the rest of your day. Harry, thank you so much. And
thank you, Beth.
thanks to all of you. Take care.
Bye.
Bye.